Chapter 3 Language of the Supreme Court, High Courts, etc. Article 348 Language to be used in Supreme Court and in High Courts and for acts, bills, etc. 1. Notwithstanding anything in the foregoing provisions of this part, until Parliament by law otherwise provides: A. All proceedings in the Supreme Court and in every High Court. 2. The authoritative text 1. Of all bills to be introduced or amended, they are to be moved in either House of Parliament or in the House of either House of Legislatures of the state. 2. Of all acts passed by Parliament or the Legislature of the state, and of all ordinances promulgated by the President of the Governor of a state. And 3. Of all orders, rules, regulation and bylaws issued under this Constitution or under any law made by Parliament or Legislature of the state shall be in the English language. 2. Notwithstanding anything in sub-clauses A of clauses 1, the Governor of the state may, with the previous consent of the President, authorize the use of the Hindi language or any other language used for any official purpose of the state in proceeding in the High Court having its principal seats in the state, in that state. Provided that nothing in this clause shall apply to any judgment, decrees or order passed or made by such High Court. 3. Notwithstanding anything in sub-clauses B of clauses 1, where the legislature of a state has prescribed any language other than the English language for the use of bills introduced in or acts passed by the legislature of the state or in ordinances promulgated by the governor of the state or in any order, rule, regulation or bylaws referred to in paragraph 3 of sub-clauses or a translation of the same in the English language, published under the authority of the governor of the state in the official gazette of that state, shall be deemed to be the authoritative text thereof in English language under this article. Article 349 Special procedure for enactment of certain laws relating to language. During the period of 15 years from the commencement of the Constitution, no bill or amendment making provision for the language to be used for any of the purposes mentioned in clauses 1, Article 348 shall be introduced or moved in either House of Parliament without the provision sanctioned of the President, and the President shall not give his sanction to the introduction of any such bill or the moving of any such amendment except after he has taken into consideration and recommendation of the Commission constituted under clauses 1, Article 344 and the report of the committee constituted under clauses 4 of that article. Chapter 4 Special directives. Article 315 Language to be used in representation of representation for address of grievances. Every person shall be entitled to submit a representation for the redress of any grievance to any officer or authority of the union or a state in any of the languages used in the union or in the state, as the case may be. Article 350A. Facilities for the instruction in mother tongue at primary stage. It shall be the endeavour of every state and of every local authority within the state to provide adequate facility for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. And the President may issue such directions to any state as he considers necessary or proper for securing the provisions of such facilities. Article 350B. Special Officer for Linguistic Minorities. 1. There shall be a special officer for linguistic minorities to be appointed by the President. 2. It shall be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under this Constitution and report to the President upon those matters at such intervals as the President may direct, and the President shall cause all such reports to be laid before each House of Parliament and sent to the governments of the states concerned. Article 351. Directives for development of Hindi language. It shall be the duty of the Union to promote the spread of the Hindi language, to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India, and to secure its enrichment by assimilating without interfering with its genuines the forms, style and expressions used in Hindustani and in the other languages of India specified in English schedule, and by drawing wherever necessary or desirable for its vocabulary, primary on Sanskrit and secondary on other languages. Part 18. Emergency Provisions. Article 352. Proclamation of Emergency. 1. If the President is satisfied that a grievance, a grave emergency exists whereby the security of India or of any part of the territory thereof is threatened, whether by war or external aggression or armed rebellion, he may by proclamation make a declaration to the effect in respect of the whole of India or of such part of the territory thereof as may be specified in the proclamation. Explanation. A proclamation of emergency declaring that the security of India or any part of the territory thereof is threatened by war or by external aggression or by armed rebellion may be made before the cultural occurrence of war or any such aggression or rebellion of the President is satisfied that there is a imminent danger thereof. 2. A proclamation issued under clauses 1 may be varied or revoked by the subsequent proclamation. 3. The President shall not issue a proclamation under clause 1 or a proclamation verifying such proclamation unless the decision of the Union Cabinet, that is to say the Council consisting of the Prime Minister and other Minister of Cabinet rank appointed under Article 75, that such a proclamation may be issued, has been communicated to him in writing. 4. Every proclamation issued under this article shall be laid before each House of Parliament and shall, except where it is the proclamation revoking proclamations, cases to operate at the expiration of 1 month unless before the expiration of that period it has been approved by the resolution of both houses of Parliament, provided that if any such proclamation not being a proclamation revoking proclamation is issued at a time when the House of People has been dissolved or the dissolution of the House of the People asked place during the period of 1 month referred to in this clause, and if a resolution approving the proclamation has been passed by the Council of States, but no resolution with respect to such proclamation has been passed by the House of the People before the expiration of that period, the proclamation shall cease to be operated at the expiration of 30 days from the date on which the House of the People first sits after its reconstitution, unless before the expiration of the said period of 30 days a resolution approving the proclamation has been also passed by the House of the People. 5. A proclamation so approved shall, unless revoked, cease to operate on the expiration of the period of 6 months from the date of the passing of the second of the resolution approving the proclamation under clauses 4, provided that if and so often as a resolution approving the continuance in force of such a proclamation is passed by both houses of Parliament, the proclamation shall, unless revoked, continue in force for the further period of 6 months from the date on which it would otherwise have ceased to operate, unless under this clause provided further that if the dissolution of the House of the People take place during any such period of 6 months and a resolution approving the continuance in force of such proclamation has been passed by the Council of State, but no resolution with respect to the continuance in force of such proclamation has been passed by the House of the People during the said period, the proclamation shall cease to operate at the expiration of 30 days from the date on which the House of People first sits after its reconstitution, unless before the expiration of the said period of the 30 days a resolution approving the continuance in force of the proclamation has been also passed by the House of the People. 6. For the purpose of clauses 4 and 5, a resolution may be passed by either House of Parliament only by a majority of the total membership of that House and by majority of not less than two-thirds of the members of that house present and voting. 7. Notwithstanding anything contained in the foregoing clauses, the President shall revoke a proclamation issued under clauses 1 or proclamation varying such proclamation if the House of the People passes a resolution disapproving, or as the case may be, disapproving the continuance of force of such proclamation. 8. Where the notice in writing signed by not less than one-third of the total number of members of the House of the People has been given of either intention to move a resolution or disapproving, or as the case may be, for disapproving the continuance in force of a proclamation issue under clauses 1 or a proclamation varying such proclamation. A. To the Speaker if the House is in session, or B. To the President if the House is not in session. A special sitting of the House shall be held within 14 days from the date on which such notice is received by the Speaker, or as the case may be, by President for the purpose of considering such resolution. 9. The power conferred on the President by this article shall include the power to issue different proclamations on different grounds, being war or external aggression or armed rebellion or imminent danger of war or external aggression or armed rebellion, whether or not there is a proclamation already issued by the President under clauses 1 and such proclamation is in operation. Article 353. Effect of proclamation of emergency. While a proclamation of emergency is in operation, then A. Notwithstanding anything in this Constitution, the executive power of the Union shall extend to the giving of direction to say to any state as to the manner in which the executive power thereof is to be exercised. B. The power of Parliament to make laws with respect to any matter shall include power to make laws, conferring powers and imposing duties, or authorizing the conferring of powers and the imposition of duties upon the Union or officials and authorities of the Union as respects that matter, notwithstanding that it is one which is not enumerated in the Union list, provided that where a proclamation of emergency is in operation only in any part of the territory of India. 1. The executive power of the Union to give direction under clause A, and 2. The power of Parliament to make laws under clause B shall also extend to any state other than a state in which or in any part of which the proclamation of emergency is in operation, if and in so far as the security of India or any part of the territory thereof is threatened by activities in or in relation to the part of the territory of India in which the proclamation of emergency is in operation. Article 354, application of provisions relating to disturbing of revenues while a proclamation of emergency is in operation. 1. The President may, while a proclamation of emergency is in operation, by order direct that all or any of the provisions of Article 268 or 279 shall for such period not extending in any case beyond the expiration of the financial year in which such proclamation ceases to operate, as may be specified in the order, have effect subject to such exceptions or modifications as he think fit. 2. Every order made under clause 1 shall, as soon as may be after it is made, be laid before each House of Parliament. Article 355. Duty of the Union to protect states against external aggression and internal disturbance. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Article 356. Provisions in case of failure of constitutional machinery in states. 1. If the President on receipt of a report from government of a state or otherwise is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this Constitution, the President may by proclamation A. assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by the governor or any body or authority in the state other than the legislature of the state. B. Declares that the power of the legislature of the state shall be exercisable by or under the authority of Parliament. C. Makes such incidental or consequential provisions as appears to the President to be necessary or desirable for giving effect to the objects of proclamation, including provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority in the state. Provided that nothing in this clause shall authorize the President to assume to himself any of the powers vested or in or exercisable by High Court, or the suspend in whole or in part the operation of any provisions of this Constitution relating to High Courts. 2. Any such proclamation may be revoked or varied by the subsequent proclamation. 3. Every proclamation under this article shall be laid before each House of Parliament and shall, except where it is proclamation revoked, a provisions proclamation cease to be operate at the expiration of 2 months unless before the expiration of that period it has been approved by a resolution of both Houses of Parliament. Provided that if any such proclamation not being a proclamation revoking a previous proclamation is issued at a time when a House of People is dissolved or the dissolution of the House of the People take place during the period of 2 months referred to in this clause, and if the resolution approving the proclamation has been passed by the Council of State, but no resolution with respect to such proclamation has been passed by the House of People before the expiration of that period, the proclamation shall cease to operate at the expiration of 30 days from the date on which the House of the People first sits after its reconstitution, unless before the expiration of said period of 30 days a resolution approving the proclamation has been also passed by the House of People. 4. A proclamation so approved shall, unless revoked, cease the operation on the expiration of a period of 6 months for the date of issue of the proclamation. Provided that if and so often as a resolution approving the continuance in force of such a proclamation is passed by both houses of parliament, the proclamation shall, unless revoked, continue in force for the further period of 6 months from the date on which, under this clause, it would otherwise have ceased to operate, but not such proclamation shall in any case remain in force for more than 3 years. Provided further that if the dissolution of the House of the People takes place during any such period of 6 months and a resolution approving the continuance in force of such proclamation has been passed by the Council of State, but no resolution with respect to the continuance in force of such proclamation has been passed by the House of People during the said period, the proclamation shall cease to operate at the expiration of 30 days from the date on which the House of the People first sits after its reconstitution, unless before the expiration of the said period of the 30 days a resolution approving the continuance in force of the proclamation has also passed by the House of the People. Provided also that in the case of proclamation issued under clause 1 on the 11th day of May 1987 with respect to the state of Punjab, the reference in the first proviso to this clause to 3 years shall be construed as a reference to 5 years. 5. Notwithstanding anything contained in clause 4, the resolution with respect to the continuance of force of a proclamation approved under clauses 3 for the period beyond the expiration of 1 year from the date of issue of such proclamation shall not be passed by either House of Parliament unless a proclamation of emergency is in operation in the whole of India, or as the case may be, in the whole or any part of the state at the time of passing of such resolution, and b. the Election Commission certifies that the continuance in force of the proclamation approved under clauses 3 during the period specified in such resolution is necessary on account of difficulties in holding general election to the Legislative Assembly of the state concerned, provided that nothing in this clause shall apply to the proclamation issued under clauses 1 on the 11th day of May 1987 with respect to the state of Punjab. Article 357, exercise of legislative powers under proclamation issued under Article 356, 1. Whereby by a proclamation issued under clauses 1 of the Article 356, it has been declared that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament, it shall be competent a for Parliament to confer on the President the power of the legislature of the state to make laws, and the authorities the President to delegate subject to such condition as he may think fit to impose the powers so conferred to any other authority to be specified by him in that behalf. B. For Parliament or for the President or other authority in whom such power to make laws is vested under subclauses A, to make laws conferring powers and imposing duties or authorizing the conferring of powers and the imposing the duties upon the Union or officers and authorities thereof. C. For the President to authorize, when the House of People is not in session, expenditure from the consolidated fund of the state pending the sanction of such expenditure by Parliament. 2. Any law made in exercise of the power of the legislature of the state by Parliament on the President or other authority referring to in subclause clause A of clause 1, which Parliament or the President or such other authority would not but for the issue of proclamation under Article 356 have been competent to make, shall after the proclamation has ceased to operate continue in force until altered or repealed or amended by the competent legislature or other authority. Article 358, suspension of provisions of Article 19 during emergency. A. While a proclamation of emergency declaring that the security of India or any part of the territory thereof is threatened by war or by external aggression is in operation, nothing in Article 19 shall restrict the power of state as defined in Part 3rd to make any law or to make any executive action which the state would but for the provisions contained in Part be competent to make or to take, but any law so made shall to the extent of the incompetency cease to have effect as soon as the proclamation ceases to operate, except as respect the things done or omitted to be done before the law so cease to have effect, provided that where such proclamation of emergency is in operation only in any part of the territory of India, any such laws may be made or any such executive action may be taken under this article in relation to or in any state or union territory in which or in any part of which the proclamation of emergency is not in operation, if and in so far as the security of India or any part of the territory thereof is threatened by activities in or in relation to the part of the territory of India in which the proclamation of emergency is in operation. To nothing in clause 1 shall apply. A. To any law which does not contain a recital to that effect that such law is in relation to the proclamation of emergency in operation when it is made, or B. to any executive action taken otherwise than under the law containing such a recital. Article 359, suspension of the enforcement of the rights conferred by Part 3 during emergencies. 1. Where a proclamation of emergency is in operation, the President may by order declare that the right to move any court for the enforcement of such of the rights conferred by Part 3rd except Article 20 and 21 as may be mentioned in the order, and all proceedings pending in any court for the enforcement of the rights so mentioned shall remain suspended for the period during which the proclamation is in force, or for such short a period as may be specified in the order. 1a. While an order made under clause 1 mentioning any of the right conferred by Part 3rd except Article 20 and 21 is in operation, nothing in that part conferring those rights shall restrict the power of the state as defined in the said part to make any law or to take any executive action which the state would but for the provisions contained in the part be competent to make or to take, but any law so made shall to the extent of the incompetency cease to have effect as soon as the order aforesaid cases to operate, except as respect things done or omitted to be done before the law as cases to have effect, provided that where the proclamation of emergency is in operation only in any part of the territory of India, any such law may be made or any such executive action may be taken under this article in relation to or in any state or union territory in which or in any part of which the proclamation of emergency is not in operation, if and in so far as the security of India or any part of the territory thereof is to threatened by the activities in or in relation to the part of the territory of India in which proclamation of emergency is in operation. 1b. Nothing in clause 1a shall apply a to any law which does not contain a recital to the effect that such law is in relation to the proclamation of emergency in operation when it is made, or b. to any executive action taken otherwise than under a law containing such a recital. 2. An order made as aforesaid may extend to the whole or any part of the territory of India, provided that where the proclamation of emergency in operation only in part of the territory of India may such order shall not extend to any other part of territory of India unless the President being satisfied that the security of India or any part of the territory thereof is threatened by the activities in or in relation to the part of the territory of India in which the proclamation of emergency is in operation, considering such extension to be necessary. 3. Every order made under clauses 1 shall as soon as may be after it is made be laid before each House of Parliament. Article 359A. Application of this part to the state of Punjab. are repealed by the Constitution 63rd Amendment Act 1989, Section 3 WEF 6 January 1990. Article 360 Provisions as to financial emergency. 1. If the President is satisfied that the situation has arisen whereby the financial stability or credit of India or of any part of the territory thereof is threatened, he may by proclamation make a declaration to that effect. 2. A proclamation issue under clause 1 A may be revoked or varied by the subsequent proclamation. B shall be laid before each House of Parliament. C shall cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by the resolution of both Houses of Parliament, provided that if any such proclamation is issued at a time when the House of the People has been dissolved or dissolution of the House of the People takes place during the period of 2 months referred to in subclause C, and if a resolution approving the proclamation has been passed by the Council of States but no resolution with respect to such proclamation has been passed by the House of the People before the expiration of that period, the proclamation shall cease to operate at the expiration of 30 days from the date on which the House of the People first sits after its reconstitution, unless before the expiration of said period of the 30 days a resolution approving a proclamation has been also passed by the House of the People. 3. During the period any such proclamation as is mentioned in clause 1 is in operation, the executive authority of the Union shall extend to the giving direction to any state to observe such canons of financial property as may be specified in the directions, and to the giving of such other directions as the President may deem necessary and adequate for the purpose. 4. Notwithstanding anything in this Constitution, A. Any such direction may include A provision requiring the reduction of salaries and allowances of all or any class of persons serving in connection with the affairs of a state. 2. Provision requiring all money bills or other bills to which the provisions of Article 207 apply to be reserved for the consideration of the President after they are passed by the legislature of the state. B. It shall be competent for the President during the period any proclamation issued under this article is in operation, the issue of direction for the reduction of salaries and allowances of all or any class of persons serving in connection with the affairs of the Union, including the judges of Supreme Court and the High Courts. The Constitution of India, Part 19, Miscellaneous, Article 361, Proclamation of President and Governor, and Article 361, Protection of President and Governor and Raj Pramukh. 1. The President or the Governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those power and duties, provided that the conduct of the president may be brought under review by any court, tribunal or body appointed or designated by either House of Parliament for the investigation of charges under Article 61. Provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceedings against the government of India or the government of a state. 2. No criminal proceedings whatsoever shall be instituted or continued against the president or the governor of a state in any court during his term of office. 3. No process for the arrest or imprisonment of the president or the governor of a state shall issue from any court during his term of office. 4. No civil proceedings in which relief is claimed against the president or the governor of a state shall be initiated during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as president or as governor of such state, until the expiration of 2 months next after notice in writing has been delivered to the president or the governor as the case may be, or left at his office stating the nature of the proceedings, the cases of action, therefore the name, description and place of residence of the party by whom such proceedings are to be instituted, and the relief which he claims. Article 361A. Protection of publication of proceedings of Parliament and a state legislature. No person shall be liable to any proceedings, civil or criminal, in any court in respect of the publication in newspaper of a substantially true report of any proceedings of either House of Parliament or the Legislative Assembly, or as the case may be, either House of the Legislature of a state, unless the publication is proved to have been made with malice, provided that nothing in this clause shall apply to the publication of any report of the proceeding of a secret sitting of either House of Parliament or Legislative Assembly, or as the case may be, either House of the Legislature of a state. 2. Clause 1 shall apply in relation to reports or matters broadcast by means or wireless telegraphy as part of any program or service provided by means of broadcasting station, as it applies in relation to reports or matters published in newspaper. Explanation. In this article, newspaper includes a news agency report containing material for publication in newspaper. Article 361B. Disqualification for appointment or remunerative political post. A member of the House belonging to any political party who is disqualified for being a member of the House under paragraph 2 of the 10th schedule shall also be disqualified to hold any remunerative political post for duration of period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or till the date on which he contest an election to the House and is declared elected, whichever is earlier. Explanation for the purpose of this article. A. The expression House has the meaning assigned to it in clause A of paragraph 1 of the 10th schedule. B. The expression remunerative political post means any office. 1. Under the government of India or the government of state, where the salary or remuneration of such office is paid out of the public revenue of the government of India or the government of the state, as the case may be. Or 2. Under a body, whether incorporated or not, which is wholly or partly owned by the government of India or government of state, and the salary or remuneration for such office is paid by such body, except where such salary or remuneration paid is compensatory in nature. Article 362. Rights and privileges of rules of Indian states. REP by the Constitution 26th Amendment Act 1971 Section 2. Article 363. Bar to interference by the courts in dispute arising out of the certain territories, agreements, etc. Treaties, agreements, etc. 1. Notwithstanding anything in this constitution but subject to the provisions of Article 143, neither the Supreme Court nor any other court shall have jurisdiction in any dispute arising out of any provision of a territory, treaty, agreement, covenant, engagement, sanad or other similar instrument which was entered into or executed before the commencement of this constitution by any rules or an Indian state, and to which the government of the Dominion of India or any of its procedure governments was a party, and which has or has been contained in operation after such commencement, or in any dispute in respect of any rights occurring under or any liabilities obligation arising out of any of the provisions of this constitution relating to any such treaty, agreement, covenant, agreement, engagement, sanad or other similar instrument. 2. In this article, A. Indian state means any territory recognized before the commencement of this constitution by His Majesty or the government of a Dominion of India as being such state, and by ruler includes the prince, chief or other person recognized before such commencement by His Majesty or the government of the Dominion of India as the rule of any Indian state. Article 363A, recognition, grant and rules of Indian state in case and privacy purpose to be abolished. Notwithstanding anything in this constitution or in any law for the time being in force, a. the prime, chief or other person who at any time before the commencement of the Constitution 26th Amendment Act 1971 was recognized by the President as the ruler of an Indian state, or any person who at any time before such commencement was recognized by the President as the successor of such rule shall on and from such commencement cases to be recognized by such ruler or successor of such ruler. B. On and from the commencement of the Constitution 26th Amendment Act 1971, private purse is abolished and all rights, liabilities and obligations in respect of private purse are extinguished, and accordingly the ruler or the case may be the successor of such ruler referred to clause A or other person shall not be paid any sum. Private purpose. Article 364, special provision as to major ports, aerodromes. 1. Notwithstanding anything in this constitution, the President may by public notification direct that as from such date as may be specified in the notification. A. Any law made by Parliament or the legislature of a state shall not apply to any major part or aerodrome or shall apply thereto subject to such exceptions or modifications as may be specified as in the notification. Or B. Any existing law shall cease to have effect in any major port or aerodrome except as respects things done or omitted to be done before the said date, or shall in its application to such port or aerodrome have effect subject to such exception or modifications as may be specified in the notification. In this article, A. Major port means a port declared to be major port by or under any law made by Parliament or any existing law, and including all areas for the time being including within the limit of such port. B. Aerodrome means aerodrome as defined for the purpose of enactments relating to airways, aircraft and air navigation. Article 365, effect of failure to comply with or to give effect to directions given by the Union. Where any state has failed to comply with or to give effect to any direction given in the exercise of the executive power of the Union under any of the provisions of this Constitution, it shall be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this Constitution. Article 366, definitions. In this Constitution, unless the context otherwise requires, the following expressions have the meaning hereby respectively assigned to them, that is to say, 1. Agricultural income means agricultural income as defined for the purpose of the enactment relating to Indian income tax. 2. An agro-Indian means a person whose father or any of whose other male pro, pro, progenitors in the male line is or was European descent but who is domiciled within the territory of India and is or was born within such territory of parents habitually resident therein and not established there for temporary purpose only. 3. Article means an article of this constitution. 4. Borrow includes the raising of money by the grants of annuities and loans shall be construed accordingly. Five. Clause means clause of the article in which the expression occurs. Expression occurs. 6. Corporation tax means any tax on income so far as the tax is payable by companies and is a tax in the case of which the following conditions are fulfilled. A. That it is not chargeable in respect of agricultural income. B. That no deduction in respect of tax paid by companies is by any enactments which may apply to the tax authorized to be made from dividends payable by the companies to individuals. C. That no provisions exist for taking the tax so paid into account in computing for the purpose of the Indian income tax the total income of the individuals receiving such dividends or in computing the Indian income tax payable by or refundable to such individuals. 7. Corresponding province. Corresponding Indian state or corresponding state means in cases of doubt such province, Indian state or state as may be determined by the president to be the corresponding province, the corresponding Indian state or the corresponding state as the case may be for the particular purpose in question. 8. Debt includes any liabilities in respect of any obligation to repay capital sums by way of annuities and any liabilities under any guarantee and debt charges shall be construed accordingly. 9. State duty means a duty to be assessed on or by reference to the principal values ascertained in accordance with such rules as may be prescribed by or under laws made by Parliament or the legislature of a state relating to the duty of all property passing upon death or deemed under the provisions of the said laws so to pass